Hey everyone, and welcome back to another misstatement by Special Prosecutor Breenan. Or at this point, can even Beverage Bev Canoni keep just sweeping everything under the rug? We had a motion filed by the defense. It's the motion that's related to Dr. Welcher. You might remember that Canoni made a ruling, I believe it was Thursday, that even though he is wildly speculating, wildly going outside of every rule she made regarding any of the defense witnesses, they can just fix it in cross-examination. Now we have a new motion where it's clear when Breenan stands up and cries about a fair trial, when he stands up and cries about, well, the defense never ever does what the defense is supposed to do, he's actually talking about himself. I'll just jump into the conclusion of this. It's 11 pages. It's a longer ride, but it's a good ride. The Commonwealth has repeatedly failed to show that Dr. Welcher's methodology is sufficient, reliable, via common acceptance in the relevant scientific technical community, or by meeting the apt Dorbert-Lanigan factors upon its original production of materials. Bev have already said, well, I don't care about that. I'll care about it if it's a defense witness, but when it's a Commonwealth witness, you can just fix it in cross. It's a new trial. I'll allow it. Dr. Welcher has strayed far beyond his area of expertise in formulating conclusions relating to the instant matter. The Commonwealth appears to have conceded this as fact and agreed to remedy the inappropriate proposed testimony. Remember, they were arguing that he took witnesses' testimony as fact. That's for the jury to decide. When Jen McCabe claims she did something with her phone and an expert witness comes in and said, well, you can't trust Selbright, trust me. That's for the jury to decide that that's a fact. That's not for some hired gun to come in and say, well, the fact of the case is, because that's not something that you can prove. Remember, everything an expert says and gives over to the defense should be able to go out, hire someone, and disprove. But you can't do that when you just stipulate that, well, Jen McCabe is a fact witness. When Jen McCabe's testimony is one of those that's quite out there, especially if you compare the different iterations that have been doing all of these hearings. Can you show me what I said? Wasn't that what she said constantly? The Commonwealth has, by its own standards set forth on March 20th, 2025, failed to do so. The Commonwealth made both substantial meaningless changes by redacting the original presentation and also notable and impactful changes to the substance of Dr. Welcher's presentation, well past applicable deadlines despite claiming the opposite and without explaining the reasons. Remember Friday when Special Prosecutor Breenan was crying about the defense turning over evidence too late? This report that he promised would be shortened, it's still the same 140 pages. I believe the original is 144 pages. But not only is it still 140 pages, even though he claimed, well, we're going to shorten it down, it was just so they had everything. But you're still giving them 140 pages, even though you told Beverage Canoni that you would go home, cut it down, so it was only very narrow what Dr. Welcher was about to talk about. Not only didn't you do that, you went home and changed the things that was in the report. They had pictures in there. It's all in the rest of the document. They had pictures in there where they had pictures from Fairview 34 with snow on it, so it could kind of give a picture of how it must have looked around that time. Those have been changed. One of them to what looks like a Google Map image with no snow on it. The other one is changed to a picture of a car park. Why? No explanation, no reason. It's just something special. Prosecutor Breenan thought that's probably what he meant when he said to Beverly Cannoni, it's absolutely not what we're doing. The redacted presentation do not address the defendant's concern nor the Commonwealth's own stipulation in any meaningful way. The proverbial waters are now more insufficient for the Commonwealth than ever before. Given that Dr. Welcher and the Commonwealth has not addressed any of the serious defects attended to Dr. Welcher, while simultaneously changing the substance of Dr. Welcher's proposed testimony in a belated any illegal attempt to bolster the testimony, the defendant and the court are actually in an even further posture of prejudice regarding the contents of Dr. Welcher's testimony than they did before this redacted presentation. The court cannot countenance the Commonwealth's approach in this regard. Dr. Welcher is merely another in the long line of Commonwealth experts where the Commonwealth does not come anywhere close to satisfying the apt law and hopes to have their expert witnesses' testimony admitted while keeping its contents vague. The important difference here is that the Commonwealth acknowledged their own deficiencies in open court only to ignore them to this moment. The Commonwealth must bear the consequence of its own action here, not the defendant or the court. For all these reasons stated here in the testimony of Dr. Welcher should be excluded in its entirety. Robert Alessi, Alan Jackson, Elizabeth Little, David Giannetti. So again, we watched that court hearing. We watched that Alessi brought this up. It was a very, very short 2-minute statement. Breenan said, I'm not going to have him testify about X, Y, and Z. Then he turns over everything with everything still in it. So he didn't go home and remove all of these parts. He testified that, well, I'm not going to use the witness's testimony from the first trial as evidence. Boom, it's still in there. I know I'm an idiot because at this point, most of the expert witnesses that Breenan has brought in should never have been accepted. I'm one of those fools who think, well, justice must be served at some point, so Beverly must wake up and remove all of this BS. I also believe she should do it at this point, and I also believe that that would serve justice. But I'm not as big as an idiot as I look, so I know she will just do what she always does. Hold the hand of the Commonwealth, deny justice, and this is becoming a problem. Because not only can you say, well, she's tipping the scale, she's firmly planting her hand on the scale, denying justice in this case, and there's no remedy until, hopefully never, when Karen Reed loses her case and can appeal it, which will be 4, 5, 6 years down the line. In the matter of this case, first of all, Special Prosecutor Breenan should take his good clothes and leave. He cried about Friday. I would never allow that on my team. He then proceeds to do exactly what he claims the defense does. Lies constantly about evidence. Then he turns in evidence too late. He changes the testimony, the evidence that he provides to the defense so they can prepare. We are starting Tuesday to find a jury in a case where a woman can lose her life. not in the way, but going to prison. If Beverly Cannoni had any moral fortitude, she would pull Hank Brennan into the courtroom Monday morning and say, "You guy, sanctions. Do you remember how much I yelled at the Commonwealth at the defense for paying a bill to ARCA? What you're doing here is unheard of. Changing the evidence you already turned over and not doing what you promised me. You out. Lally, you little bald-headed fool, get back here. You have to do it." Sadly, that's in Baker's dream world. In reality, I'll allow it. You can fix it on cross. The Canton Triangle, as always, is strong there. No justice, no sense, no science, just a very highly biased judge and a special prosecutor who doesn't care that his morals are lacking.